Welcome, everybody, to the very first episode in the Keeping It Real podcast for the law office of Kevin Pritchett. I just decided that I was going to do this podcast, and as the title suggests, Keeping It Real. I'm not going to have any fancy studio, at least not yet anyway. It's just going to be kind of quick overview, little bite-sized morsel lessons of things that I think you all need to know and that come up in the practice all the time. The very first topic I'm going to go over today in this podcast, and it's only going to be maybe 5-7 minutes, 9 minutes, something like that. So you don't have to lay out 55 minutes of time. Quick little tidbits to give you good information and things that you need to know. Way too many people misunderstand this very important issue of an estate plan. I don't go by a week. No week goes by in the practice without people calling me about clients having issues around this, people having problems around it. So let's get this straight right from the beginning. I guess I should have introduced myself. Those of you may or may not know who I am. My name is Kevin Pritchett. I'm an attorney, been an attorney for 37 years. That's right. Abraham Lincoln and I went to law school together. It was actually my idea for him to free the slaves. I digress. I've been practicing in the area of business law, corporate law, estate planning, and retirement planning that entire time. This is an area that I know a great deal about. I've probably drafted several hundred trusts, if not thousands of trusts for clients over the years. This one topic gets so misunderstood and it causes problems. Not a week goes by in the practice where I don't get a case or several cases from someone who died and they didn't title the property correctly and the family has to go through gyrations in order to either get the property, sell it, or what have you. So let's start right now getting this estate plan stuff straight. You see here on my screen the components of an estate plan. Too many people misunderstand and believe that a will prevent them from having to go to probate. Now, little background. Probate court is the court that's specifically designed to handle issues when people die. For example, if your father owned a house and he was the only one on title to that house, once he is dead, there is no living person that is on title that can sign a deed or can do anything around the property. So the heirs have to go to a probate court. Now, here's where the misunderstanding occurs. People think that if they have a will, that they don't have to go to probate. Nothing could be further from the truth. A will is only a roadmap that the judge uses to decide who gets the property. If you say that Elroy, if your deceased father says Elroy gets the property, then the judge will review the will and say, yes, Elroy can get the property. But before that happens, there is a very complicated, intricate process and procedure that has to go through. You have to file in a newspaper that so-and-so has died in order to give creditors a chance to file claims. If anybody disputes that Elroy should get it, they can file a petition with the court, and it becomes litigation. Everything in the estate also becomes public. You don't want that. Oh, and did I mention that to go to probate court, clients have to give me a minimum of a retainer check of $5,000 plus expenses, and I bill by the hour. And that's what all probate attorneys charge. It's very expensive and so unnecessary. So point number one in this estate planning little lesson is a will does not help you avoid probate. A will is only a roadmap through, I was pointing to the living will. I should have been last will here. A will is only a roadmap through probate. If you don't have a will, then there is, each state has a statute that gives a hierarchy of who gets property if there's not a will. You really don't want that, because who knows who could get the property then. So let's get this straight. A will does not avoid probate. You want to avoid probate court if at all possible because it's expensive, makes your estate public, and it takes, even if it's uncontested, could take 9 months to 12 months to get fully resolved. What you want to distribute your assets is a living trust. A trust is just a legal entity that owns things. Think of a trust the way you would think of a will. If you want Elroy to get the property and to get your gun collection, you state in the trust that Elroy gets so-and-so and so-and-so. Now, let me make this additional point about real estate. Even if you have a trust, and a trust can be changed at any time, the components of a trust are a trustee. That's the person who creates the trust, or the grantor. Trustee are the same. And then if the grantor dies, the successor trustee is the person that's designated in the document to take care of things. Then there's a beneficiary. A beneficiary is someone different from the trustee. The trustee has a responsibility to carry out the provisions of the trust. The beneficiary is the person who gets stuff. The beneficiary can be the trustee, and in most families, that's generally the case. So, the trust, revocable living trust, is the document you need that an all estate plans must have in order to distribute assets. Just because a piece of property is listed in this document, that's not all that's required to transfer title to that real estate to the trust. What's required is to create a deed. So as part of this, I guess I should have put a deed under here as one of the elements if there's real estate. A deed has to transfer title to the property to the trust for the property to be in the trust. Not enough that it's just listed in the trust. The second document is a last will and testament. Well, wait a minute. Kevin, I can hear you now. Kevin, didn't you say that the will isn't what you need to distribute stuff? That's exactly what I said. But you do want a will as part of a proper estate plan. Belt and suspenders. There may be some stuff that slips through the cracks, an argument, whatever. A will is a part of an estate plan, but you don't want it to do the heavy lifting. You want the trust to do the heavy lifting because a trust is not a public document. You don't have to file it anywhere, record it anywhere, and no judge or court has to authorize a trust. All right, so we're moving on here. First component of a proper estate plan is a revocable living trust. Revocable living trust means the grantor or the person who creates the trust can change it anytime they want prior to them dying. But after they die, even a revocable trust cannot be changed anymore. Its provisions get locked in, and the trustee doesn't have discretion on whether to implement the provisions of the trust. The trustee must carry out the provisions of the trust. Okay, so we've got the will, which is belt and suspenders. That's the second part. A living will. Here on this list, it's called a living will. In Illinois, where I practice, it's called a power of attorney for healthcare. Different states call it little different things. Sometimes it's called a living will. Basically, though, it's the document that names the person that you give the authority to make decisions for you, medical decisions, including end-of-life decisions, in the event that you are not able to do so. Here's the scenario. You get sick, deathly sick, and you're in the hospital, you're on life support, and the doctors basically have told you there's no hope, there's no prognosis. Well, what do? Do you leave all life-supporting devices in? Do you take them out? Does the doctor make the decision? What do you do? The heirs, and I've been in this situation personally with my own family, it is an agonizing decision. My family and I had discussed what to do. So I had my directions because I was the one responsible for it all. But you don't want the heirs without this power, this living will or power of attorney for healthcare. The heirs won't know what to do, and that's a really agonizing decision. Should I pull the plug? Should I not? The document lists what your wishes are, and it also names who your agent is, the person who you designate as a person who will take care of these things. So everybody knows what's going on, clearly stated, and every state has what's called a statutory short form. It doesn't have to be a long, drawn-out document. It doesn't have to be super intricate or anything. Be very simple. And this document is a legally binding document that hospitals have to abide by too. So when you fill out your living will or your power of attorney for healthcare properly, it has to be witnessed and notarized. Your signature has to be notarized, and it has to be a witness to your signature in addition to the notary. Then if the document says that I name Kevin as my agent and Kevin will have the discretion, then if in the situation in the hospital I say, okay, we're pulling the plug, the hospital has to abide by that decision because it's a legally binding document. Let me just add to that the trust is signed by the grantor or husband and wife, grantors, both of them, and then it's notarized. Those are the only legal requirements. A will, last will and testament, has to be signed, and then it has to be witnessed by 2 or 3 people. Your signature has to be notarized, and the witnesses have to attest that they signed. So there's a lot of signatures and notaries that are required for a last will and testament. Only thing needed is your signature and a notary for a trust. Living will or power of attorney for healthcare, you sign it, your signature is witnessed by a notary, and then there's one witness. And then the last document is a power of attorney for property. That is a document where you name an agent. And again, let's say you name Kevin as your agent and you get sick. You don't die, but you can't handle your business affairs. You're not mentally competent to handle your affairs. You name an agent, somebody who can handle a whole list of business affairs for you. Same deal. Your signature gets witnessed, and then there's a witness, and then your signature gets witnessed by a notary, and then a witness also witnesses your signature. That's the requirements for a power of attorney for property here. What that document does is says, Kevin can handle my business affairs for me. It's only good while the grantor is still alive. If the grantor dies, then that power of attorney for property document is not effective anymore. The other documents in your estate plan would then kick in. The last component here that I have here that's important is to update your estate plan regularly. One of the biggest things that people don't take enough time to take care of are the beneficiary provisions on their bank accounts, on their IRA accounts, 401k accounts, changing beneficiaries on life insurance, annuities, any contracts. Those documents, IRAs, 401ks, life insurance does not have to go through a trust. You just want to make sure the beneficiary provisions on those documents are the way you want them and review them every year. So I have annual reviews for my clients to make sure that everything is shipshape and is the way that they want it. If it isn't, we either amend the existing documents or create new ones. Friends, that is your trip through a proper estate plan in less than 15 minutes. If you have questions on any of this, put those questions down in the chat wherever you're seeing this content. If it's on my Facebook page, put it right there on the Facebook page. If it's in an email, just reply to the email. If it's on my YouTube channel, just put comments down. I'm going to start a weekly feature called Ask Me Any Questions. and I will be answering questions that people ask. Okay, friends, I hope you've enjoyed this Keeping It Real podcast episode. It's kind of fun doing these things. And we'll change up the format too. I may have guests on, we may have interviews, I may go to different places and record the podcast, but it's going to be a regular weekly feature. And then in conjunction with the weekly podcast, I'm going to answer questions that people submit. So I hope you enjoyed this and found it helpful. If you have suggestions for topics you'd like me to talk about on the podcast, just leave those in the chat below wherever you're looking at the content. Okay, keeping it real. This is Kevin Pritchett for Law Office of Kevin Pritchett. Talk to you soon.